Good morning. Are you Trinity Hughes? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hughes, in cause number 25 DCCR 0770, you're charged with the state jail felony offense of unauthorized use of a vehicle from May 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Hughes is not competent?
No, Your Honor.
And any history?
There's some slight history of in Orange County, some cases that were refused, Your Honor, but no convictions or anything like that. So I would ask that we go forward today.
Okay. So, Ms. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report and to find sufficient evidence to find you guilty and follow your agreement and defer all proceedings for a period of 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because you don't have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed. You'll never have a conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? Also, it's important for you to know that if you get on probation, do everything you're supposed to, pay your fees, fines, show up, do everything. I sign early terminations for probation all the time. So if you do it all correctly up front, then you likely won't even have to do the whole 5 years.
This moment right here is critical and easy to misunderstand if you're not familiar with deferred adjudication. Trinity Hughes isn't being let off. She's being given a legal tightrope. 5 years of deferred probation means no felony conviction if she follows every single rule, miss one payment, fail to report, or violate probation, and the court can instantly convert this into a felony conviction with up to 2 years in state jail. But here's the flip side. Do everything right, and this case disappears like it never happened. So the real question is, can she handle that responsibility? Or will this second chance become her biggest
convictions? And that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998 and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of 2 delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year?
I believe
Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
State jail. State jail, Your Honor.
State jail
Give me a
time.
second.
Yes, they did.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's
No,
two
you
cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in clause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25, DCCR 0498, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0499, also find that you entered your plea of guilty freely and voluntarily and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time.
Notice the
I've
sharp contrast here. Perry Robertson isn't being judged on just one mistake. He's being sentenced on a lifetime pattern. The judge carefully reads years of prior convictions, and that history completely changes the outcome. 5 years in the Texas Department of Corrections, with sentences running concurrently, means no probation, no reset button, no safety net. This is how repeat offenses compound in the justice system. Each prior conviction narrows the court's options until prison becomes the only path left. So let me ask you, should the system focus more on rehabilitation, or is this exactly how accountability is supposed to work?
You don't need to tell me all that. I've been down this road.
I know.
I started laughing. I said, I guess you have.
Yeah,
I started saying, look at the paperwork, Judge. Man, I know all this. I can just say.
he probably could. DeMarcus Senegal.
I'm going to tell you all later on about James Macon.
Oh,
Oh, my God.
Good morning.
Good morning, how are you? Actually,
Good.
what he says is pretty bad. So I'm pretty glad. Surprised you did.
Good morning. Are you Jamarcus Senegal? And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Senegal, in cause number 20-33924, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2020 for the offense of deadly conduct discharging a firearm, a third-degree felony, and that was a 10-year term in prison that was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample June 2nd of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample July 3rd of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample August 14th of 2025 that also tested positive for cocaine. Is that true or not true? And then count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Senegal is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I may have gone over that with you, but I don't think I started that in 2020. But because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff, and thank you for being here.
This video shows how different people face very different outcomes in court, all based on choices, history, and timing. One person gets probation and a fresh start. Others lose their freedom after violating trust. That's the reality of the justice system: clear, strict, and unforgiving. If you found this breakdown helpful, like the video, share it with others, and subscribe to Law Nexus for more real courtroom
This
stories
courtroom
and
session perfectly captures how justice isn't just about the crime. It's about credibility, compliance, and consequences. Trinity Hughes leaves with hope, but only if she earns it through strict probation. Perry Robertson and DeMarcus Sagal, however, face prison after repeated violations and broken trust with the court. The judge's rulings are consistent, firm, and legally grounded, showing how opportunity shrinks as history grows. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe to Law Nexus for more jaw-dropping courtroom breakdowns and real legal insight.